but it's the practical reality, or not. It's the actual reality in the city that in 2020 voted 92% for Joe Biden, 5% for Donald Trump. So that it goes without saying that that's what the juror questionnaires are going to say. Now, do I think you can get a fair trial from those jurors? I no. Can you get a trial that the judges will say that the jurors are at least willing to represent, that they'll be unbiased and consider the case only on the evidence? Sure. Is that the truth? No. But as I said to a judge, not in DC, in a different case that's high profile that I'm involved in that has the same kind of issues, it's a legal fiction that our jury selection operates in. The legal fiction being that undisclosed bias can be weeded out and revealed through voir dire. It's not going to be revealed if the juror doesn't want to give it up. The juror is just going to answer the question the way he thinks the judge needs to hear he or she answer the question to stay on the panel.
Hey, Culminators. Welcome back. Thanks again for joining us. I am so excited about this. This is one of those cases where either I never met someone and they tell me this story for the first time and you get to share that magic moment with me, or it's someone that I tell you that I've known for years and years and we've never had a chance to really talk face to face. This is a little bit different. And I even actually just found out a little bit more about our joint relationship, well, what kind of relationship can there be? About a joint friend of ours, or perhaps a former friend. This is William Shipley. Bill Shipley, who is better known to people on Twitter and on the internet, including in the old blogging world, as Shipwrecked Crew. Bill, welcome to the show.
Thank you, Ron. At long last, I begged and pleaded, and you finally found a slot for me.
You did not. All you had to do was tell me you wanted in, and this is going to be a lot of fun because there's a lot of cool stuff going on here. And one of the interesting things about you, besides the fact that you've been active on social media since the old days, as I have been, is that besides being a J6 lawyer now, which we'll talk about in a second, you on Twitter have come in for some of the most ferocious criticism from the crowd that tends to see things very much in black and white. In other words, if you're not savaging the FBI, everything about it, top and bottom, inside and out, then you're a Fed, or you're part of the deep state, or you're a fanboy. And I don't think one thing I don't expect that from and don't see it is from lawyers, because lawyers understand how complex institutions and relationships and partisanship in the world of law and law enforcement can be. But now that you've become a January 6th lawyer, I imagine that you're not experiencing quite as much of that. Talk about that in a second. Tell the folks about your background, because it's a fascinating one in and of itself. And also what you just mentioned to me before we started recording about how you and I actually go back further than I had previously appreciated.
Yeah. Okay. And those two are intertwined a little bit, kind of interestingly. And I was for a decade and a half, maybe 2 decades almost, anonymous on social media, going back to the old blogosphere days where that was really the only social media, individually written and produced blogs that spanned the spectrum of politics, and was known as Shipwrecked Crew. Now, the origins of that particular pseudonym are simply that it was the first name of a fantasy baseball team that I started going back in like 1989.
Surely it's not an allusion to Gilligan's Island somehow. I mean, when I think of a Shipwrecked Crew, that's what I think of.
Right. And it long before I moved to Hawaii, it had nothing to do with that. And then
he lives in Hawaii. He lives in Hawaii. I'm talking to someone in Hawaii. How do you like that?
And that's the sun in my face, peeking in through the window, coming up over the Pacific with a nice little ocean breeze. No, so and it later became the first email name I ever had, and it has just
What was it?
through
Shipwreck crew at AOL.com or
no,
CompuServe?
no, well, it was at one time. It was probably AOL, the first one.
Yeah,
So it has just stuck around for through no particular or just by happenstance for 3 decades, and it just sort of moved with me to the internet. Our shared history that I mentioned to you before we started was I wrote anonymously at Patrick Fry's blog, Paterico.com, way back 15 years ago. And at the time, well, still is. Patrick's an assistant district attorney in Los Angeles County, and I was at the time I first crossed paths with him, and assistant U.S. attorney in the District of Hawaii. And there it is. And after, he had a really extensive comment following, and you could write the longest comments you wanted. There was no limit on the comments.
sure.
And after, a lot of time writing in his comment section and commenting on federal criminal cases and federal criminal law and politics a little bit, he just reached out to me via email and said, would you be interested in being a guest blogger? In other words, putting up posts myself to add to his content on the areas where I had some subject matter expertise. And so I did I did for a little while, and then I dropped off for a few years. Well, I know when I dropped off. I dropped off at the beginning of the Obama administration. Became a little bit nervous about, aggressively blogging on conservative causes when now all of my supervisors in the U.S. Attorney's Office in Hawaii were all, on the other side of the political spectrum. So I just, I kind of dropped out for a long period of time, and then went back in 2012, 2013, because I knew I was going to be leaving the U.S. Attorney's Office soon after that, and I left in May of 2013. Kept up, and I remember, I knew you were there because you represented Patrick in a slander case brought against him by somebody that he commented about. Those details, you can share those if you want. Had a great outcome for him. All worked out terrific. We were all on Team Patrick. I remember asking Patrick one time, and this is well after, the blogosphere had sort of just been taken over by websites, places like Powerline and Hot Air, and you had more corporate media coming in and kind of displacing the individual guy in his pajamas in his basement as which was pajamas media back in the day,
Right.
PJM. And I said, do you think you could ever do this again? He goes, absolutely not. I was just in the right place at the right time, caught lightning in a bottle. I never imagined it would turn into what it became. And then, as you know, and we don't have to go into this in any detail, Patrick and some others that we were both familiar with became never Trumpers. And there was a break, a fracturing, and it was not pleasant, and it was ugly. And lots of things were exchanged back and forth. I can't say that I was really a Trumper at that point. I was always a Cruz guy.
Yeah,
But
I was a Cruz guy. That was really who I was, hoping would get the nomination, and I always felt that he would have gotten it if it hadn't been for what's his name down in Florida,
Rubio,
Rubio. Really insisting on, I'm here to win Florida. I'm going to win Florida. I mean, Cruz would
right?
have won Florida, I think. Well, whatever. Uh,
So that
Trump
2000,
had to grow on a lot of us.
yeah, 2016, it just came to an end. But and then I reminded you that I had that connection, and at that time was still anonymous, and remained anonymous even for many years after that for reasons that probably don't really want to talk about too much. But in October of 2021, after I had decided to take the plunge on some January 6 cases, Leslie McAdoo Gordon, another friend of ours, mutual friend, she asked me, okay, if you're going to do this and your name's going to be out there on pleadings and whatnot, is there any reason to remain anonymous? And I said, no, I don't think so. And so she announced to the world on Twitter who Shipwrecked Crew actually was once I began making appearances in cases in October of 2021.
And would you say that by virtue of that experience, you would reconsider any of the things you said about the Bureau prior to October of 2021?
No, no. And here's my explanation. I
Let's get.
spent 22.
I'm assuming people know what you and I know, but let's give a little background about
Sure,
what I'm
sure.
talking about.
Yeah. So I started in the Department of Justice in 1992. I was hired in the U.S. Attorney's Office in the Eastern District of California. I had a little bit of an inside track there. 105 people applied for one position, and I knew somebody who said, I can get you an interview, but you have to get yourself the job. And I got the interview and I got the job. And that was 1992. It was in the civil side. I was a civil litigator. I came out of a civil litigation firm and got a job as a civil litigator. I did that for 2 years, and it took me that long to figure out that there are no juries in civil litigation with the government. So I wanted to try jury cases. I did not really expect to be attracted to the criminal side. I never really wanted to be a district attorney or anything like that. But that's where the jury trials happen. So I wandered down to the other end of the hall and talked to the chief about whether I could switch sides, and he said, sure. So just like that, I became a criminal prosecutor in 1994. And as I just mentioned, I left the Department of Justice in 2013. So my plan all along was to just stay 5 years, try some cases, and then go out and be a big plaintiff's lawyer. And 22 years later, I left. So plans change. Now here's the issue of why the Bureau has changed, why the Department of Justice has changed, and why my experiences there were absolutely, true and honest as to the era and aren't necessarily the same anymore. And it's taken me some time to come to grips with that. Even when I left, both the Bureau and the U.S. Attorney's Office were undergoing real cultural shifts. And that was 100% a result of the change in recruiting during the Obama administration. If you'll recall, late in the Bush 43 term into 2007, 2008, there was a lot of controversy about Federalist Society lawyers populating throughout the Department of Justice. And coming out of law schools after the Iraq War, it just became a real hotbed of liberalism. Not that they all weren't always, but I mean, it really became an issue. If you remember all the litigation, all the big firms stepping up to represent Gitmo detainees, and those are all, the ACLU, and I'm not begrudging that point of view. I mean, the system works best when it's balanced on all sides.
That's how old we are. We remember when that might have arguably been the case for a minute or two.
Right. So the Obama administration began to aggressively hire, law school graduates who had the right kind of resume entries. Now they claim they never did, but I know for a fact that if you had a resume entry in 2009, 2010, 2011 that showed you were a Federalist Society member, you couldn't get a Justice Department job. Those just, you had no chance. But if you had the Sierra Club or
Lawyers
ACLU
Guild.
Lawyers, then you got the interviews and those applicants got the jobs. And that over time slowly began to populate the Department of Justice from top to bottom. And then, when you spend another 5, 6, 7 years and those people begin to move up the chain, they then become the hiring crew. And the same thing happens even faster in an institution like the FBI. So with the FBI, what happens is they have a mandatory retirement at age 50 or retirement eligible at age 50, mandatory at 57. And most FBI agents are at least 25 when they get hired. So you've got that like 25 to 30-year window that the entire workforce turns over. The entire workforce, within 25 to 30 years, all the agents that were hired are gone. So think about that in these terms. Agents that were hired right after 9/11, 2001, they're in there coming up on their 22nd year. all of the 9/11 agents, all the agents hired in the aftermath of 9/11 will be gone in 4 years. Gone. All the agents hired during the Clinton administration are pretty much gone now. And what one of the things that was true of FBI recruiting in the 90s and then even in the early 2000s was the recruiting tended to favor ex-military types, because you think about when the Clinton administration hollowed out the military as the peace dividend. Not necessarily a bad thing, but the Soviet Union disappears, and now you've got a friendlier Russia under Boris Yeltsin.
You can quibble about the wisdom of the policy, but it was in and of itself not an irrational policy.
Yeah, but it happened. I mean, a lot of the officer corps were discharged, and that became a recruiting ground for federal law enforcement across all the agencies, including the FBI. So you had a lot of military. You had a lot of state and local law enforcement who wanted to jump to the feds just because of the different challenge. And that was, the incoming recruiting classes at the FBI Academy were largely male. They were largely alpha male, dominant, military officer types, leadership. And that remained true in the aftermath of the Iraq War. Again, you've got a lot of military personnel coming out, looking for jobs in federal government so they could maintain their retirement system. And that was your workforce up through about 2006, 2007, 2008. It all changed with the Obama administration. In the same way the Department of Justice recruiting changed, in the Obama administration under Robert Mueller, as we all lived through, diversity became the catchword. The workforce needed to reflect the population. Mm-hmm. And where did they go to find those people? They went to college campuses. So the FBI's primary recruiting ground for the last 15 years has been college campuses. So think about what comes off of college campuses these days. J. Edgar Hoover was always proud of the fact that a lot of his agents were lawyers and accountants.
Right. That's when we were growing up in the 60s watching Ephraim Zimbalist Jr.'s FBI. That was the image, and that was the truth. That was the FBI, all lawyers and accountants who reluctantly learned to go into law enforcement, and became the best cops and the most ethical cops in the world, and saving us from communism and that kind of thing.
But starting about 2000, 9, 10, 11, 12, 13, now you've got all of these humanities majors. You've got all of these soft social science majors who are beginning to populate the lower ranks of the FBI, and something that most people don't know, and I don't know that it's really ever changed. It was a shock to me when I found out. But the track into management at the FBI is in the initial stages based on volunteerism. If you want to become an FBI manager, you want to move up into management, transition out of doing casework, because FBI supervisors don't do casework. They quit being, in effect, agents. They become managers. The way you get started down that path is you raise your hand. Raise your hand. I want to be a manager.
Oh, I see what you're saying. Okay.
It's not based on merit. And as a result, as many FBI agents, veteran FBI agents will tell you, some of the supervisors were some of the worst agents because they were bad agents and they opted to go into management to avoid, doing work they didn't like or they weren't very good at.
So it's a kind of accelerated Peter principle.
Exactly. So, but so as a result, the culture of the FBI begins to shift as the hiring priorities shift, the recruiting priorities shift. Now we're a decade plus into that. And those people that were hired at the beginning of the Obama administration or in the first 2 or 3 years when these recruiting priorities changed, they're all now in management.
Only the worst of them, or many of the worst of them.
Right. So that's why you end up with a politicized FBI, and that's why you end up with a shifting priority in the FBI that reflect political sensibilities, not, law enforcement priorities.
Of course, I mean, Clyde Tolson was not exactly the epitome of a great a great agent, even though he was a favorite of J. Edgar Hoover's. My understanding is that he was a rather mediocre agent himself. Is it? I mean, you're not former FBI, but you're speaking from the experience that you picked up hanging out with G-men as a prosecutor. I'm correct about that, right?
Absolutely.
Yeah.
For 20 plus years, on the criminal side, I worked early in my career, probably the first 7, 8, 9 years. I worked primarily, not exclusively, but primarily with DEA. When I was in California, I did a lot of drug cases. When I came to Hawaii, the slot that they offered me was a white collar organized crime slot. And that brought me into a lot more contact with the FBI, but also with the IRS criminal investigators. I did a lot of work with them. I liked working with the IRS because those guys were accountants, and I only had one outright tax trial. I swore I'd never do tax cases, didn't want any part of it. I had one outright tax trial, and the IRS agent said, "How about if I just write the questions and the answers for you?"
Oh, God.
I said, "I'm good with that."
I hope it was as long as it was direct.
Yeah. Oh, yeah. It was his direct.
Okay. Because I'm cross, you sure as hell better understand what you're asking.
Yeah.
Okay.
So so I did a little more than 10 years in both offices. I was left in 2013, have done some civil litigation, have come to really dislike doing the discovery on the civil side. I just, with an entire career based on, criminal defense work, I kind of just like the run and gun aspects of criminal defense better than the, depositions and document productions and interrogatories and requests for admissions. That stuff just wears me out.
I mean, I have to have other people basically run discovery for me because I don't have the patience for it. And the spats and the hiding the ball crap, let someone else fight that out. You know how long it's been since I've done a live cross-examination? I mean, trials ground to a halt 2 years ago. I mean, unfortunately, you're busy with trials, but on the civil side, there are so few civil trials now, and I really miss being in court. But to me, the most fun you can have with your clothes on is cross-examination on an order to show cause or a preliminary injunction evidentiary hearing, because you've been sandbagged per se. You've got virtually no time to prepare, which gives an advantage to the geniuses among us, and people who just have that ability to hear something that doesn't quite sound like the phraseology of someone who's got nothing to hide. Anyway, enough about
that's actually, and that is, I find in doing what I'm doing now, that's a huge advantage, because as I say to individuals, look, we're in federal court, and these criminal cases that I'm doing on January 6th cases are all in federal court. And as you know, a huge swath of lawyers in the country want no part of federal court. They're intimidated by it. They're intimidated by the courtrooms. They're intimidated by in the criminal case, the Department of Justice on the other side. They're intimidated by the federal judges, who tend to have a lot less patience for bad lawyering. But, it's all I've ever known. I've never tried a case in state court. I've only been in federal court my entire career.
That is a largely charmed life from the point of view of a federal litigator. I've been admitted to the New York bar since 1989. Never tried a case in New York. New Jersey, plenty, because you know what? It's a lot like the federal system. The rules are very similar, and the judge quality is quite high. But I wouldn't, I want to be in federal court almost all the time.
Well, the thing I tell people when they talk about federal court practitioners and whether lawyers are cut out to be in federal court or not, or whether they experience, I said, look, here's the thing about federal court is there's a language that goes along with being in federal court. Understanding the rules of evidence, understanding the rules of procedure, whether it be civil or criminal, and right away when somebody doesn't understand the language that they don't have any experience, and the judges know. If you can't speak the language of the rules of evidence or rules of procedure in a federal courtroom, the judge knows immediately. And generally, you don't get a lot of, you're not going to get a lot of calls go your way, because the judge knows you're just guessing.
You're right. You're right. And also you need to know the local custom. Somebody sent me a bunch of papers on a case where I was local counsel, and I said, this is a perfectly good set of papers for the District of Maryland. But in New York, in the Southern District of New York, we don't say this honorable court. That's not language we use. Here's what our papers look like. It sounds trivial, but almost every court is provincial to one extent or another. Right. If they think you're from out of town, I tried a case in Phoenix, and first of all, the court reporter wanted to kill me because I was talking so fast. This Jew comes out from New York, and he never heard anything like this, and I'd never had a problem with a court reporter anywhere else in America. But the judge was so damn good, Judge Teilberg. I think he's retired now. He was so damn good. Well, I won, so I'm prejudiced. We all hung in there. Listen, this is too much inside baseball. Although people do like that stuff. You were just, to sum up, you're talking about the changes that the Justice Department in general, both on the investigatory side and on the prosecution side, have gone through culturally, and it's really different now. And you've assimilated that difference after a couple of years now in the trenches on this J6 stuff. Of course, you're also in the most insane district, of which I'm a member myself, so I must speak with discretion and caution and respect. But the District of DC is, wow.
Well, I have had good experiences in that courthouse in terms of, the judges. It's an interesting place. It is obviously, it has a political spectrum that is well known because it's in the political city. Now, I have a point of view as whether there even should be a circuit or a district there.
You hit the nail on the head. And people want to turn a city. The whole idea of turning a city into a state or making a special district and a court of appeals, a circuit for one city
that sits on top of one district. And I've made this point to some of the judges. I said, Your Honor, I've got to say, I'm used to. I spent my whole career in the Ninth Circuit. And the Ninth Circuit, right. you've got a circuit court with 26, regular judges plus a whole litany of senior judges, and you've got, probably 25 or 30 district courts feeding decisions up to that Ninth Circuit, and that Ninth Circuit pumps out opinions on all manner of cases. And I go looking for court authority in the circuit of the district, the circuit court for the District of Columbia, and I don't find anything. Right. Because they basically got cases that are coming from 13 judges. That's it. And it just doesn't produce the same. And the types of criminal cases, unless there's some sort of DC-centric, DC-venued governmental fraud case or something, the types of cases that come out of the DC District Court are not terribly complicated. If you look at the case authority, and even the January 6th cases, other than some issues, I tried to tell prosecutors it's an assault case on video. I don't care where it happened or what day it happened on. It's an assault case on video. Let's talk about the evidence.
Yeah. So did they even want to have the conversation? I wouldn't think so, because I think they've succeeded in getting the panel of judges in that circuit to literally and explicitly take the position that, yes, these are political crimes. We have a lesson to teach. This is a moment of truth for our country, because this was an assault on democracy. Literally an assault on democracy.
Right.
Did they hear you? Did they respect that position, or did you get blown off?
Well, the prosecutors?
Yeah.
I'm going to be careful what I say here, because I'm sure they will all listen to this at some point. I've developed a little bit of a reputation among the prosecutors now, because a lot of them are relatively new. If you think about, so consider this: the District of Columbia U.S. Attorney's Office has a certain number of AUSAs. It's not like they got 100 new AUSAs to do these cases, and they have other work. It's not like they could just set everything aside that they were otherwise doing to just handle these cases. It's hundreds
Right.
of cases have been brought.
There are other
So,
Republicans to prosecute
right.
besides J6 people.
So as has happens often in the government, it happened when I was there. The executive office of U.S. attorneys sort of sits on top of all, 93 districts, has dragooned prosecutors from across the country to handle, a small number of these cases. And so if you're this, let's say, just for example, let's say you're the U.S. attorney for the Northern District of California, an EOUSA, Executive Office of U.S. Attorney, says, I need two of your people to handle January 6th cases. Who are you going to give them? You're not going to give them. You're going to give them the kids. You're going to give them the least experience.
Doesn't want to be away from home and his kids and his. Well, if he's married long enough, maybe he does want to. Okay, but
or diverted from some big, long-standing investigation that's important to the office and important to the law enforcement agencies. You're going to give them the inexperienced, newer prosecutors for the most part, not exclusively, for the most part. And the U.S. Attorney's Office in the District of Columbia tends to have a high turnover rate anyway, because people going into that office are heading for law firms. They're going in for 4, 5, 6, 7 years, and then for the most part, they're out. So somebody said, I don't know if it's completely accurate or not, but in the Oath Keeper case that I did, the second Oath Keeper case, one of the other lawyers said, I think you've got more federal trials than all the prosecutors combined, which I think is probably pretty accurate in pretty much any courtroom I go into. I have, one of the funny things that I've encountered is in 22 years, 20 years as a criminal prosecutor, I only had 2 cases where I had co-counsel, twice. My very first case where I was the co-counsel, and then a case about 6 or 7 years into my career, which went 3+ months. And the office said I needed somebody helping me. I didn't walk around looking for somebody. The chief said, I think you need somebody to back you up in that case because it's too big for one person to handle alone. Okay, and I did, and it worked out fine. But every other trial I handled, I did by myself. I come into these J6 cases, a case that's going to take a week with video evidence, and there's 4 prosecutors. 4 prosecutors. I made fun of this going way back before I started doing this. I made fun of the Roger Stone prosecution by the special counsel's office because that, the obstructing Congress, lying to Congress case against Roger Stone at the end of the Trump administration. They had 4 prosecutors on that case, 2 special counsel lawyers and 2 assistant U.S. attorneys from the District of Columbia. They had 5 witnesses. They called 5 witnesses in the case. It took 4 prosecutors to call 5 witnesses. It's like, this is a comedy. Why? What is going on? Why are you guys doing this? Well, it turns out they're doing it because they all want to get the trial notation on their resume. So when they go apply to Jones Day or whoever, they can say, that they are tried federal criminal cases in the District of Columbia. So it's just like, these are entertaining. These kind of little factoids cause me to chuckle. I walk into a room, I'd see 5 prosecutors. It's like, all right, let's get started.
Yeah, well, it's interesting to know what you're saying is that a lot of people don't realize that lots of people with the title of assistant U.S. attorney haven't tried all that many cases.
Less so now than probably in any time in the last 30 years. Part of that is COVID. It really kind of slowed down the whole process, and now, it's just odd to me. So if you want to be a trial lawyer, be a trial lawyer. Go and try your cases. Don't drag 4 other people in with you to share the responsibility.
Well, that's what happens when no one's paying for it.
All right.
All right, let's talk about what's going on with January 6th, because we've already chewed up, believe it or not, and lawyers like us, old lawyers who are comfortable in court, could definitely tell stories for a very long time. Maybe we just do a live stream and people, jump in, and because I think people really enjoy it. But let's talk about what you're doing now and how that's affected your take on the federal on the justice system.
Well, I I have to be careful, obviously, you're mindful of the
and
ethical rules.
I'm not baiting you. I'm not. In other words, I'm looking to you for, I think, as good as anyone. I had another guest a few weeks ago who feels very burned by the system. Another lawyer, J6 lawyer, but I expect to hear a more nuanced presentation from you.
Well, okay, so the way I came into these cases, and I don't want to talk too much about the details, but there was another lawyer who I knew. I didn't know him well. I'd never met him in person. Only knew him. We had worked briefly together on another case where we just sort of came together by happenstance. And I came and went from that other case and just had a couple of interactions with him online and a couple of phone calls. So then he was representing multiple January 6 defendants and seemed to have some issues in the summer of 2021 that were, kind of playing themselves out in the media and on social media. And I just sent this person an email that said, remember me? We worked together on this other case, AUSA for 22 years. I see you're involved in these January 6th cases. Do you need help? And his one word response back about 5 minutes later was yes. And so that led to a phone call and discussing, what was going on and how I might be able to provide him some assistance. At that point, I wasn't admitted to the DC court, so I couldn't actually just start making appearances. And the arrangement was I would help kind of behind the scenes. I would look at the felony cases, evaluate the evidence, talk to the clients, and then over time, once I got my DC bar admission worked out, maybe start to make some appearances. And we'd just start slowly, and I'd make appearances as necessary, not just wade into all the cases at one time. Well, that relationship was fine for a period of time, and then some external events and external forces kind of some things happened. And become beyond either of our control. It wasn't something between us. It just some external issues arose. And I ended up kind of separating myself and going a different direction. And most of the clients who had felony cases, who I'd been interacting with quite a bit and knew my background, opted to stay with me. And so that would have been like the winter and spring of last year. Got my DC bar all ready to go as of April 1st, 2022. And I think I made like 12 or 16 appearances over 2 or 3 days. Just filed notice of appearances in a variety of cases. And then all of a sudden I'm representing 20 January 6 defendants all at one time.
So non-lawyers should understand that making an appearance in the 21st century means electronically filing a paper that metaphysically or symbolically amounts to your appearing in a case. So now you've made an appearance. I've appeared in cases all over the country, in courts I've never stepped into, most of which end up settling because I do civil work, which most cases end up settling. But so you can, that's how you can do 21 appearances in a day.
Right, exactly. So at that point, I'm an unknown quantity. I'm some guy who used to be a prosecutor stuck on a rock out in the middle of the ocean, a long ways away from the DC courthouse. And all of my relationships with the clients at that point were either via email or phone calls. I started to make a few Zoom appearances with some of the judges. And I mean, I don't frankly know what kind of impression I was making at that time. I remember my very first appearance with Judge Maida in the Oath Keeper case after I came in for Roberto Minuta in April of 2021. And that case was fast-tracked for a trial at that point in September. So I only had 5 months. And I, first appearance there, there's 9 or 10 lawyers on the line. And the case has been around for a year already. And there had been nonstop complaining about the government's production of discovery for a year. And so Mr. Judge Maida turned to me, Mr. Shipley, you have anything to add to whatever we had been talking about? And I started to complain about discovery. And he listened to like 15 seconds and he cut me off. And he went on to another lawyer. And I thought to myself, well, I guess I made him mad or something. And it dawned on me later. My thought was, I was wasting his time. Those complaints had been made since the case started. And I wasn't doing anything at that point constructive. I was just listening to myself talk. Um,
All right. I mean,
which
listen, you didn't necessarily have time to read every transcript from every hearing. You had to make sure you had to observe what you were seeing and what you were experiencing. You're looking at an empty red well in terms of Brady material.
right. So, but thereafter, I when asked, I always felt like I had something substantive to say that was meaningful to the hearing. And I developed, I thought, a pretty good relationship with Judge Maida. And by the time we got to trial, um, I felt in many respects that he was listening to my comments and often siding with me. And from the first Oath Keeper case, which I was not in, the one that had Stuart Rhodes and all the big shots in that, the government won pretty much every argument over the evidence in that case. And then in the second case, which my client was in, I think the government lost over 50% of the arguments, and they weren't very happy about it. And then I've had experiences with. I think I
I
counted
also
the other
want.
day.
I also for non-lawyers, evidentiary rulings and evidentiary objections, when to make them, when not to make them, how to make them. This is really where the men and the boys are separated in. I mean, not this. There are other places too, but this is one of the areas where really experienced trial counsel makes a gigantic difference. So the fact that you, with your experience, were able to get such different results. I know you're not telling me this for purposes of crowing about your success, but I am telling the listeners that it's the pilot, it's not the plane when it comes to
Yeah,
evidence.
well, and I think that kind of goes back to the comment I made a few minutes ago about speaking the language, and the important thing that people need to know is, for the most part, the trial judges at the district court level, they have tried hundreds of cases. They have more experience trying cases as a judge than all the lawyers in the room.
Right.
And so the ruling on making rulings on the rules of evidence are like that's like the back of their hand. They know that stuff cold. So unless you can offer objections within the context of what they're expecting to hear, you're going to lose right before you finish your first sentence. The objections have to be made within the context of the rules of evidence. And if you have the context right, then it goes to what's the nature of your argument. And if you have both of those right, you stand to win. And the judges, that's how they hear it. That's how it lands on their ears. If you have the context wrong, well, judge, it just seems to me, it's like, well, that's not an objection.
And also,
So,
there's a credibility factor. People who watch, and federal cases are not televised, but the LawTube crowd, which includes many of my friends, they doing these live coverages for entertainment purposes of state court cases in those states that allow cameras. Why didn't he object? Why didn't he object? I'm not talking about, most of the lawyers who are watching understand that there are times not to object, but there there's lots and lots of questioning that is technically objectionable. You got to choose your spots. You want, Ted Williams, when Ted Williams took a pitch, umpires understood it was probably not a strike because Ted Williams was up there to hit. And it's the same thing with trial objections. If you object every time there's a complex, a multi-part question, or there's a little bit of leading on direct, the judge is going to just tune you out.
right. Yeah, and I, sometimes, you generally know what the answer is going to be. You've had discovery. You know what this witness has said in their interview. You know what the government usually constructs their direct from the evidence, the 302s or other the wire intercepts, whatever. And as long as you've read your discovery and done outlines for each witness, and you know the nature of their testimony, even though the form of the question might be objectionable, you know what the answer is going to be. And you might want the jury to hear that answer because you have something you're going to do with that answer on cross.
Exactly.
So
Exactly.
it's tactical and strategic. So I like to let stuff come out sometimes because it's something that I'm going to make use of, even if I could object and maybe win the objection.
Bill, we're never going to cover all the stuff. Sum up for me. Where do things stand? Is it as some people say an utter travesty, or are people getting a fair shot? I mean, one of our mutual friends who's down there with you guys in trying these cases has told me, you have to remember that most of the guys who are being prosecuted should be prosecuted.
Mm-hmm.
Should they be treated the way? Should they be in pretrial detention for 2 years? Should they be in solitary? Should they be getting felony? Those are all issues we can discuss. But the idea that this was, according to him, merely a case of, the Capitol Guards opened the door and people just walked in. What's wrong with that?
No.
That's not really the stuff.
And this is the stuff that, as you started out with, gets me so much, criticism on Twitter. The one thing that I have always tried to do, because it entertains me, for lack of a better reason, is to be a truth teller. I don't mind poking the tiger even on my own side, so to speak. And there are some very well-known tigers on my own side that I will poke and say, you know what, you've got it wrong. I'm in a position where I have a grasp of the facts, and you're speculating about things that you don't really know, and you've got it wrong. And
not
I'm
only
not
the
shy.
facts, but also the experience and the law.
Exactly. And I'm not shy about saying that because I see even inaccurate information from both sides, to me, is misinformation. Sometimes it's purposeful and that becomes propaganda.
That is disinformation.
Exactly. But I'm just, from my point of view, I'm just correcting the record because I have subject matter expertise that most people lack.
Let me just remind you that even when you walk into federal court, you might have more trial experience than 30-year-old AUSAs put together. But on Twitter, everyone's a bigger expert than everyone else on all fields, but especially the law.
Yeah, the Google University degree. No, and I find, to me, that it's entertaining, and I can get acerbic, I can get condescending, I can I can do all those things, but my view is, look, if I have to sort of whack you across the nose to educate you and everybody else, then so be it. And I generally don't, it's not usually gratuitous. It usually comes in response to somebody wondering about me being a Fed. It's like, what? Okay, 22 years, yeah, I was, and I learned a lot. I learned a lot in those 22 years. So the J6 cases. I will say this: when we screened 175 juror questionnaires in the Oathkeeper case. You had long, detailed questionnaires about the Oathkeeper organization and the publicity surrounding. Some of the questions early on in that were just asking the prospective jurors, what are the news sources that you consume? I mean, 90% of the juror questionnaires had some combination of, and it had 3 lines. They could put their top 3. 90% of them had some combination of the New York Times, the Washington Post, NPR, BBC, MSNBC, CNN. Yeah. Though, I mean, but it's the practical reality. It's the actual reality in the city that in 2020 voted 92% for Joe Biden and 5% for Donald Trump. So that it goes without saying that that's what the juror questionnaires are going to say. Now, do I think you can get a fair trial from those jurors? No. Can you get a trial that the judges will say that the jurors are at least willing to represent, that they'll be unbiased and consider the case only on the evidence? Sure. Is that the truth? No. But as I said to a judge, not in D.C., in a different case that's high profile that I'm involved in that has the same kind of issues, it's a legal fiction that our jury selection operates in. The legal fiction being that undisclosed bias can be weeded out and revealed through voir dire. It's not going to be revealed if the juror doesn't want to give it up. The juror is just going to answer the question the way he thinks the judge needs to hear him or she he or she answer the question to stay on the panel. And that's my concern, is that there is a significant number of people coming into the DC courthouse as jurors who want to be on the panels and then will say, "Oh yeah, I can be fair."
And
I
that's
watch
not
hundreds of.
normal. I mean, you always know during jury selection, and the people you most want, especially if you're a defense lawyer in civil, are the people who least want to be on the jury. They're the people who identify with your client. They have real jobs they'd rather be at. They're they're not rooting necessarily for the underdog. They're comfortable with the establishment. Now in Washington, that's those terms have very, very different meanings. But if you have people in Washington, well, so many of them work for the government, they're not worried about their jobs, and they identify with the government. And I guess the thinking must be among the bench there that if they start granting motions to change venue in any case, they'll have to.
Well, let me tell you what's behind that. It's a very simple proposition that you'll understand as a lawyer. Maybe we get a little legal lesson to everybody who's listening. In 1973, the D.C. Circuit in United States versus Haldeman, shockingly, said in response to a change of venue, reviewing change of venue denial, um, affirmed the denial and said, for all practical purposes, that the district court judge must attempt to pick a jury before concluding that no unbiased jury can be found and transferring the case to another jurisdiction. It's in the Haldeman case, and that's binding circuit precedent. And I've made the point to the district judges, and they kind of shrug that the world has changed quite significantly in the 50 years since Haldeman was decided. Haldeman Watergate. It's like, well, yeah, it was a big thing at the time.
That's literally 50 years ago. You're right.
Yeah, it's 50 years ago. But the way people receive and consume media is not the same now. I mean, it's no longer Cronkite and the other two guys. It's no longer three networks and two newspapers, which is what it was in 1973. ABC, NBC, CBS, Washington Post, New York Times. That was pretty much what everybody consumed their news from. I don't know, USA Today didn't exist at that point. And that's just not the landscape today. And so, but it's not going to change because the judges all read Haldeman as being binding. The Haldeman says you got to try to pick a jury. So they're all trying to pick juries, and believe it or not, they're managing to find jurors who say, "Oh yeah, I watched videos all day that day, and I've spent a lot of time on YouTube, but I can put all that aside and just judge it on the evidence."
The only way the DC jury pool problem gets solved is by eliminating the DC jury, the DC district and circuit, integrating it into the Fourth Circuit, make it part of Virginia. It'll still be blue as hell. Still be blue as hell. You'll be in there with Northern Virginia. I'm not even insisting on Maryland. I'll give you Virginia.
Well,
but at least there'll be some filtering.
Right. Well, the circuit is going to have to grapple with denials in this case, and in all of these cases. I mean, there have been dozens and dozens of change of venue motions made and denied. And then those cases have gone on for trials. And so those issues are preserved for appeal. So that's going to be raised in somebody's conviction pretty soon before the DC Circuit. They're going to have to revisit Haldeman and decide whether they're going to affirm Haldeman, that the judges have to try to pick a jury first. And then that potentially is going to end up in the Supreme Court. Some of these cases Supreme Court's going to have to take on one or more of these cases and validate what DOJ has done and what the district courts have allowed. And say it was all okay or it wasn't. Maybe it's this 1512 issue and the definition of corruptly that substantially narrows that statute and the way it's being used, in which case hundreds of convictions will be thrown out. So those are all things still yet to come, but people don't understand this is the nature of how the system works. You have to go through a trial. Decisions get made.
That's your refrain, Bill, and that's what you are always bringing to the table. People base too much of their expectations in social media and in the human version, the meat space version of social media, on what they see on TV.
Right.
That's not how things work. It's not the speed at which things work. There's a lot of education that could and should be done. Reading your stuff is one way that I think people could do it. Believe it or not, this is it. We're out of it. Bill Shipley, Shipwreck Crew. We're going to have to continue this somehow, somewhere. Fantastic spending time with you. Anything I want to point anyone to
Well,
anything
let
going
me let
on?
me yeah, let me just say this, please, because I am representing defendants who could not afford their own lawyers and had appointed lawyers that they were unhappy with, and I have taken pretty much every case except for one or two based on I will fund it through crowdsourced public donation fundraising. And so my clients that I'm representing, 30 of them, cannot pay for their legal defense, cannot pay for me to fly across country and stay in hotel rooms and give me money for cat food. And so there's a Give Send Go site called the January 6th Legal Defense Fund. There's a couple of imitators. Mine can be identified because all 30 of my clients are listed on the site. I put on the site the names of every defendant being supported by the donations. Um, January 6th Legal Defense Fund. It's a Give Send Go account.
Is that it?
Yep, that's it. That's it. That's Jake Chansley on the left, the QAnon shaman, who I am preparing to file a petition to set aside his conviction.
I would hope so. Well, my friend, thanks again. You're doing God's work and you're doing a lawyer's work. And we love what we do when we get to do it.
Happy to be back anytime, Ron. It was great to meet you in DC, and I look forward to this being a long and lasting friendship.
See you soon. Thanks again.
Take care.